So let's talk about, we just finished a little bit of discussion about diligence. So in the process of managing and licensing intellectual property, when you either do diligence on yourself, which I would call an audit, right? I audit my own intellectual property to see what I own and where gaps in title might be, or after you conduct diligence on someone else's portfolio, you'll often find gaps in title, right? Which I described with that logo that the software company had. We had to go fix that gap in title to make sure we could then exploit that IP. So let's talk about perfecting the portfolio a little bit before we talk about specific other licensing issues. So to perfect the portfolio, probably one of the most important things is registrations, right? You'll find in the process of managing an IP portfolio that the intellectual properties are not registered for one reason or another, a lot of them. And it could be your job as the lawyer to fix that. So let's talk on an IP by IP basis. We covered this a little bit yesterday, but from a copyright perspective, does anyone know the process for obtaining a registration in the United States? And in some of your countries, there is no registration for copyright, right? Is that what you said yesterday? No registration for copyright?
Yeah. We do have copyright law.
You have the law, but do you have a way to get a registration from the government?
Also, we have the Office for the Registration. There is a procedure also, but okay, personally, I haven't dealt with it.
You haven't done it?
No, I haven't done it, but there is Office for the Registration. There is also the law.
So, in the United States, registration of a copyright is very, very simple. It's as easy as opening a new Netflix account, right? You go to the U.S. Copyright Office website, copyright.gov, and there's an online form. You just fill in the name of the author, the title of the work, the date of authorship, and most importantly, your payment information, because that's what the government really wants. And you click submit, and you've submitted an application for a copyright registration. As I mentioned yesterday, it takes 3 months to get that, or 6 months if you want to complete the paper form. But a copyright registration also in the United States is very affordable, $35 if you do it online. If you do the paper form, they want $60. So, because they have to pay someone to open the envelope and then data input, etc. So I tell my students in the United States, many of whom are interested in the entertainment industry, tell them if you're a songwriter, you should register your copyrights. It's easy, it's fast, and it's affordable enough. Now, a college student, $35 can be a lot to a college student, but still, if they believe in the intellectual properties that they're creating, they should go through the process. So that's how you perfect your portfolio where copyrights are concerned. It's easy. You can do it on one copyright basis, 5 minutes. You've got your registration on file. Trademarks, much harder. Has anybody registered a trademark in your territories? And what's the process? Paper or online?
Paper.
Okay.
But it doesn't happen much work.
Okay. Fill in the blanks.
Filling the blanks. You stick up the logo.
Yeah.
There is a part of the application where you can put the logo.
Yeah.
You can make it with the glue.
Yeah.
Then you send 3 copies of that, and that's it.
You know how much it costs? Do you remember how much it costs?
I think that the whole cost is around 120 euros.
Okay.
All the costs with the paid 10 years of.
And it's for 10 years.
Yeah.
But I think it's for trademark.
Trademark, 3
Yeah,
classes.
trademark.
3 classes.
3 classes.
Oh, for 3 classes.
Yeah.
For 3
Okay.
classes.
And I think it's for not all countries, right?
This one is no, just for Macedonia.
Just for Macedonia.
Okay, so, and for people who aren't familiar with intellectual property law, there are different classes of trademarks, right? If I want the IIT Chicago College of Law mark registered for education services, that's one class. If I want it registered for paper goods, that's another class. If I want it registered for clothing, that's another class. I think there are 60 international classes of trademarks. Thankfully, it's standardized on an international basis.
Nichan convention.
Huh?
Nichan convention. Nichanska.
Yeah. Most countries have adopted the same international classes. So, cause me to lose my train of thought, you talkers. Yeah, trademark.
Trade secret?
No, we're still on trademark. In the United States, the process is more complicated than that. And you can do it online, or you can still do it in paper, and they charge you more for the paper version than the online version. But the U.S. Patent and Trademark Office requires the applicant to get very specific about the trademark classes. So not only does the lawyer have to choose one of the 60 classes, or however many there are, 60, 61, whatever it is, within the class, there are a number of choices. Like, okay, you choose the class for clothing,
Yeah.
but then you have to choose, is it t-shirts or trousers? And actually, the process of filling out the application in the United States takes even a trained lawyer probably an hour to go through all that, pick the right selections. Much more complex than a copyright registration. And the U.S. Patent and Trademark Office recommends on its website that consumers not try to register trademarks on their own, that they hire legal counsel to file a trademark application. And so in my firm, we have a flat fee for trademark work, so I can tell clients with certainty how much it costs. The fee for a single trademark in a single class in the United States is $275, that's to the government. And then our legal fees, the whole thing with the $275 is $1,100. So that's what we charge for trademarks. So I tell students and clients, copyrights, easy and cheap, do it on your own. Trademarks, you really should have a lawyer. This is exactly what it will cost, not even an estimate. Here's the cost, the fees and costs. I'm interested in your perspective because you're all from first to file countries, about whether you would search a trademark for any competing users before you recommend to a client that they register.
Yes.
You would search.
I usually take the client's logo and search. On a net there is the database on the website
Of registered marks, database of registered
Yeah.
marks, right?
the.
So do you care about unregistered marks in your territory?
No.
Right.
Why should I?
Well, in the United States,
I should.
remember, one gets trademark rights by using a mark in commerce. And regardless of whether someone has a registration, they might have superior rights to my client. And so in today's world, many clients are comfortable just searching, not Googling, searching for the mark that they want to use. If it's a word mark, that's easy. If it's a logo, that's harder. They just search the internet for the mark they want to use, and finding whether there's a competing user out there. From the lawyer's perspective, I advise them that that's not enough. Yeah.
Yeah, it's not enough.
And what more would you do?
I was just thinking that it's not enough, but in US, I don't know what you can do more since there is no registration, because everyone is more safe. I wouldn't search only on internet, but also file an application near the office to ask them their information regarding the registration.
Yeah.
But in US, because it's not necessary to be registered, very difficult.
Yeah, so I mean, it's not something that a lawyer really should do on their own. So in the U.S., there's a process for this. There are companies. The largest one is a company called Thompson Reuters. Have you all heard of them? Reuters is a news service. Thompson Reuters is basically a data company, and they do searches for unregistered trademarks, and they'll search the internet, but they'll also search other places, like they have access to databases of Secretary of State records. The Secretary of State is the office in every state where the corporations would be filed. Yeah, and you have to, and they can search all those on an automated basis, all 50 states. They search newspapers and telephone books, and they have these, access to databases that would be cost prohibitive for us to get on a one-off basis, but since they do it for client after client after client, they have access. And they deliver a report they charge probably $900 to do this search, and they send a report, and it's $900. And if you were to print the report, it's probably this thick, with double-sided, and 5 potential problems on a page. So they'll send you a report that lists 10,000 potential problems for any mark you want to register. And then it's the lawyer's job to go through that. Most of them aren't a problem. You can go through like, no, not a problem, not a problem, not a problem. But in those 10,000, you'll find, depending on the mark your client wants to register and how fanciful or descriptive or common it is, you might find a half a dozen problems that you have to tell your client. Look, the advice to give a client about a trademark is, I can never tell you a perfect green light, go ahead. But I can tell you, yellow light, and I can certainly tell you red light. I can apprise you of the risk.
100% sure.
Right. But all we can do as lawyers is be reasonable, right? I did the diligence I could do, and I advised the client. Here are some problems I uncovered. This competing mark could come back to haunt you. So I just had this the other day. Oh, I had a client, I don't remember the mark they wanted to register, but it was for like a health clinic or a series of health clinics. And there was, the search report uncovered another series of health clinics in another state. My client was in Illinois. The search report uncovered pretty much the exact same business with the exact same name, but in Texas. And I got the search report. My client really wanted the mark. So what I said was, okay, well, look, in order for this to be a problem for you, what has to happen? Number 1, they have to find out about you. Number 2, they have to care. Number 3, they have to have the money to pay lawyers to sue you. And number 4, you have to not have enough money to fight back and find some argument why you're not infringing. And I told the client, that's the reality. It could be a big problem, and you could invest a lot of money in marketing this name and building your brand, and then have to change it, because that's the consequence when you're infringing a trademark. You have to stop using the mark. And the client decided, okay, I'll take that risk. But fine, I did my job. I told them about the risk, and you can believe it was all in writing.
Excuse me, there is something still, it's not so clear to me.
Yep.
Okay, there is no obligation to register a trademark. But by the other side, when I do my job very good as a business, and I want to register it, to be more sure,
Sure.
because nobody invite me to do so.
Yeah.
It's not an obligation, but it's not even, it's allowed.
It's a good idea.
And this data searcher, sorry for this data searcher company is still not 100% sure about the information. Doesn't cover 100%. Huh?
Yes.
So in any case, one tomorrow, if somebody else has the same thing, there is no chances for me that I have registered it to prevail.
No. I mean,
It's more strong the fact that
they were the prior
doesn't need
user.
registration than the fact that I have registered, I have a plus, let's say.
No.
No, I'm just asking.
No. No. That if there's a prior user, at least from a legal theoretical perspective, if there's a prior user, they win. But from a practical perspective,
How do you see as a prior or no? Because prior, maybe I will sing to the others
Well,
that
they-
I have registered the mark.
well, they would have to prove that they're a prior user, but it would be easy, even if you're let's go back to the pizzeria, right? It's a pizzeria. It's one guy in Texas. He's got a small shop, but he can probably show me a sample of the very first paper menu he did that he handed out to people on the street corner, and he probably could show me a receipt from the printer for those menus that puts a date on it.
That is approved,
Yeah, so it could be a proof problem, but in the practical sense, if you pay for this $900 search and they don't find the prior user, practically the user's pretty small. The search is very comprehensive, right? They still could be out there, but from a practical perspective, they have to be there, number one. You did the search, you didn't find them, but if they're there, they have to find out about you,
Yes.
they have to care, and they have to have money to pay lawyers. That's unlikely, I think. And in the end,
I think you should amend the law and do it who has registered prevails.
yeah,
I think that it doesn't have so much securities.
yeah. I'll bet there's an answer out there as to why the U.S. has the system it does. I don't know the answer. Why are we first to use and the rest of the world is first to file?
American dream.
Because that's when it is effective, actually. That's when it has its effect on the people, on the market. And
yet this
either
is
you
the
file
sense
or
of the
not, because
trademark.
you were doing business for a couple of days.
Yeah,
But you had the idea, you put that logo, so that's reasonable for me.
yeah. I think it's reasonable too.
It's filing is just a proof,
Yeah,
formal proof that, okay, that trademark does exist, but
yeah. When you file for a trademark in a first to file system, do you have to submit a specimen of actual use?
yes.
No.
Well, you said there's a place for the logo. That would be a
That's
logo,
a specimen. Yes,
a specimen, but of actual use?
No.
Like,
No,
no.
actually.
So in the United States,
Just
yeah.
Just the logo.
Yeah. So I should know the answer to this, but I'm blanking on it. In your territory, can I get a registration on a mark and never use it, but still own?
Yes.
Yeah.
Yes. Can't do that in the United States. So
That's
to your point too, it's sort
It's
of like
connected to the market, that's connected to the use.
yeah.
If
If
there is
someone
a
else
trademark at the
argues,
end, so you have
regarding
This
this,
is the use.
What?
if someone argues regarding that, you can lose someone.
Oh, okay. They can cancel your registration.
Yeah, I think that they can argue about that.
Yeah. Okay.
There is possibility to argue that and
Right.
take over your.
Well, that makes sense to me too. From the government's perspective, unless somebody's taking issue with it, why would they
I'm
care?
not sure about this. I think that there is possibility of all.
Right. From the government's perspective, why would they care? All they want is the registration fees.
Yeah.
Right. So if you're willing to pay, they'll take your money and say you have a mark
Okay.
until somebody has a problem with it.
Yeah.
Yeah. Okay. All right. So that's trademark registration. Now, patent registration, perfecting the portfolio where patents are concerned. Copyrights cost $35. Oh, I didn't say, I didn't wrap up cost on trademarks. So on trademarks, to get that report is $900. I always estimate for clients 3 hours of lawyer time to look at it and write you a letter about what I find. So that's $1,500 for me. And then the registration, assuming you want to register the mark after you hear what I have to say about the potential competing marks, another $1,100. So trademark start to finish, I usually say something like $5,000, $3,000 to $5,000 to register one trademark. A lot of clients don't want to do the search. You tell them about the search and that it's a good idea, and they don't care. They're like, I'll take my chances. I don't want to spend that money now. Just register the mark. And the U.S. Patent and Trademark Office will issue a registration as long as there's not a competing registration. They don't do any common law searches. They don't do that $900 search themselves. So to your point, just because I have a registration doesn't mean I'm not infringing. And I tell clients that all the time. But still, many clients don't want to do the search. More clients than not in today's world don't do the search. They just go right to registration and take their risks. Even big companies who can afford the searches. All right, so patents. Almost no way a non-lawyer can successfully prepare a patent application in the United States. If it's an engineer, the actual inventor, and they have seen and worked with a lawyer on 10 or 15 patent applications previously, maybe they could do one on their own by that point, right? Because a patent application includes a narrative description of the invention in a very arcane style of writing. Non-lawyers, I often, probably more often than not, cannot understand after having read a patent application what the invention is. Right? So they'll talk about, we had that picture of the adding machine up there yesterday. A device with keys that is capable of generating addition, multiplication, subtract, it will just describe, eventually you'll get there, but a layperson could never really understand what the invention is. You can't just say, my invention is an adding machine.
A robot.
A robot, yeah. I tell clients, you probably can't do it on your own, don't even bother trying. And, by the way, to the extent to which trademark applications are $3,000 to $5,000 as compared to $35 for copyright, a patent application is going to cost you, start to finish, by the time the patent is issued, $15,000 at least, 15 to 25. Okay, and most of that is legal fees. I think the U.S. Patent and Trademark Office fee is $600 or something like that. I put the fee schedules for patents and trademarks are in the materials that were distributed to you. Not the ones you were supposed to read in preparation before coming to class, but the ones that we have for discussion while we're here. I don't want to go through them line by line. I don't want to consume all that time on that. But that's what I basically say about patents. You can't do it on your own. You need a lawyer. At least $15,000.
Lawyer and someone from the field. So,
What's that?
lawyer and someone from the field. Because
I didn't understand you.
lawyer and someone from the field.
Oh, and someone from the field. Yeah, absolutely.
Which you are patenting.
Yes, absolutely. All right. So, segue to a new topic. All right, now let's talk about licensing, and then valuation, and then we'll be on to looking at some actual license agreements. So, someone tell me, in your words, what is meant by an exclusive license? Even if you're not an IP lawyer, there should be at least an intuitive meaning to you. What's meant by exclusive license? Yeah.
Giving the right just to a person or an entity and nobody else to use your invention,
Yeah.
to produce it, to use it,
In a certain
produce
area.
it.
Could be in a certain area, could be worldwide, but yes.
And this is meant specifically for him only,
For
but no, let's stick it's, you give it just one person?
yes.
Or one entity only? And no other person has the right to use?
Yeah, that's the
This is
answer.
exclusive.
Exclusive. I'm giving one license to you and nobody else. And by the way, with an exclusive license, it means you're exclusive. Not even I, the owner, can use my own intellectual property, right? Exclusive
Can
license.
you do it, if I remember, both two ways, by selling? No, that's not the way the payment.
Well, you could also sell it.
Payment,
You could also sell it, but that's not a license, right? That's a conveyance of title. So an exclusive license, I'm licensing it to you and I don't even retain the rights myself. Distinguished from exclusive license is what's called a sole license, S-O-L-E. That means I'm licensing it only to you, but I am retaining the rights myself as well. You can use it and I can use it. That's called a sole license. I'm only giving one license, but it's not exclusive because I'm not excluding myself. And then there's non-exclusive, which, of course, intuitively, I can grant to you, I can grant to you, I can grant to you, I can grant as many licenses as I want. And within these three categories, exclusive, sole, and non-exclusive, there are a lot of different things that can affect the licensee's right to use the intellectual property under that license. I could grant an exclusive license for a certain territory, or to use with a certain type of product, or for a certain term, right? I can also grant a sole license for a certain territory, or for use with a certain product, or for a certain term, or non-exclusive, right? And as we talked yesterday, these are some of the things you would find in an IP license that you wouldn't find in other types of contracts. How long do you get to use it? In what geographic area? For what purpose?
Sub-licensing.
Huh?
Sub-licensing.
Can you sub-license? Correct. And if you take copyright, for example, since a copyright embodies 5 different exclusive rights: reproduce, distribute, derivative works, publicly display, publicly perform, I could grant 5 exclusive licenses. You have the exclusive license to distribute copies. You have the exclusive license to make copies. You have the exclusive license to make derivative works. And I'm not breaching my obligation to any exclusive licensee by doing that. I have a bucket of 5 things, and I can do whatever I want with each of the 5. What are some of the benefits to a licensor from doing an exclusive license? Why would I do an exclusive license if I'm the owner of the IP? Or why would I do a non-exclusive? You pick. Which one do we start with? Exclusive, non-exclusive. Why good or bad for me, the licensor?
You choose the licensing.
In the exclusive situation,
Yes.
I choose who it is. But I choose the non-exclusive ones too. Right?
One of the benefits.
Usually it's the licensee that is asking for an exclusive license. Because
Okay.
licensor
Why
is not willing to have an exclusive, he wants to have too many licenses. as
Maybe,
possible.
but maybe as the
The
licensor,
question is, why to license? Why either exclusive or non-exclusive?
yeah.
Why to choose to license? Because as we said even yesterday, maybe I'm not able anymore to, or I don't have the possibility to produce by myself, or so I choose to license somewhere somebody else.
Right.
Exclusively or not exclusively is another issue.
Yeah, but how do you choose as between exclusive or non-exclusive? How can exclusive be good for the licensor? Why wouldn't I just go all non-exclusive?
They take more money for a fee.
What's that?
More money from the fee.
More money.
Bigger control on the,
More
more control.
As a licensor, I would have more control over one licensee.
Yes, and then you have more protection
Okay.
from potential.
You trust only one?
Trust only one. So that could be good or bad, right?
Yeah, this is the point. Can be good or bad.
So I'm hearing a lot of sort of good, like, tip of the iceberg thoughts, right? Let's dive deeper. So as the exclusive licensee, you talked about price. If I'm granting an exclusive license, I might be in a position to demand a higher royalty rate from my licensee, right? And tell the licensee, I'm licensing to you. I'm licensing only to you. There won't be any competitors. So I want a higher royalty rate than I would want from you if it were non-exclusive. So that could be a benefit to me of granting an exclusive license.
Financial motivation always.
The financial
Financial
motivation.
motivation always.
But what's a downside of granting an exclusive license? I've licensed to you exclusively now. I got a higher royalty rate. I'm feeling pretty good. What can go wrong for me with an exclusive license as opposed to if I had made a non-exclusive license for a little bit less royalty rate but with 5 of you? What could go wrong for the licensor in an exclusive license situation?
The risk will be very high regarding only to one party. So if he fails, then the licensor will fail.
Yeah, if he fails, that's it, right? I haven't hedged my bet, as they say. If I've made a wrong choice, I lose everything. High risk, high reward. Also, not just on the financial front, but let's say that the exclusive licensee is the only one putting this product in the market. So if I had 5 licensees, consumers would be seeing product from 5 different producers. If I have an exclusive, and they start manufacturing inferior product, the whole world sees the inferior product. That is also a risk for me with an exclusive license. Again, I haven't hedged my bet, but this one isn't on a financial front. This one is on the quality of goods and services front. So this is telling us, well, maybe in some instances a non-exclusive license is a good idea, right? I can hedge my bet. I can spread my risk. But what are the potential disadvantages of a non-exclusive license? How is that bad for me as the licensor? Well, number one, I might get a lower royalty rate from each one. Okay, I'll trade that for spreading my risk. How else could non-exclusive go bad for me as a licensor?
It cannot factor quality.
It's harder for me to monitor quality because I've got to monitor 5 now. Yeah, and that goes beyond quality. It goes also to the issue of, for example, payment. If I have an exclusive licensee, I get one royalty check, I get one royalty report. If I have to audit the licensee, I got 1 to audit. If I have 5, now I'm getting 5. And I have to worry about whether they all pay me and whether they're accurately reporting. And if I want to audit their reports, I have to go to 5 of them. It's a much higher transaction cost for me. Yeah.
I think the perception of the general public should be considered in the marketing sector too. Because when, let's say, a luxury firm, they tend to exclusive just to issue an exclusive license, let's say in an emerging market, only to one person. So to keep high standards, let's say, oh, this brand new firm came to our country. If it's distributed, maybe it won't have the same effect. And people will say, oh, too many have this.
Yeah.
But it depends, is it a luxury firm or not? It depends on what kind of business.
Yeah, okay. I'll go with that. I'll buy that. I'm thinking of, it's a funny story because next door to my restaurant in Chicago, there's an Italian restaurant run by an Italian guy, and he's kind of like a mover and a shaker. And he just got the exclusive license to some Italian electric bikes. Very high-end product. You've seen the electric bikes. Does anybody have one? I don't either, but I've seen them, and I think they cost, you can buy an electric bike for $500. He sells electric bikes that are $6,000. They're very cool, they're very fast, the batteries last a long time. But to your point, he's the exclusive guy for the whole United States because it's this luxury product and they want to enter the market that way. From my perspective, I think about this Italian company, I'm like, I'm thinking about the risk. Why would they put all their risk with this guy? Because I know the guy. He's drunk half the time. His restaurant's not very good, but anyway, he sells these $6,000 bikes. Okay, fair enough. So this is, another thing that clients sometimes will do. Like I said, they'll tell you, how should I price this IP? Tough for lawyers to answer. Sometimes they'll say, should it be exclusive or non-exclusive? We can't answer that question, at least without exploring it with the client. Well, what do you want to accomplish? What risk are you willing to accept? What problems are you looking to avoid? We can help clients reach those decisions, but we can't make the decisions ourselves, and we can't say which is better in response to a bald question. What's better, non-exclusive or exclusive? I can't tell you. Depends what you want. All right, now let's talk about valuation. So this is historically very rough for clients, or for lawyers. I've had clients come to me and say, what should the royalty rate be? Like the Monster Garage gym, right? How much should I charge as a royalty and a percentage, or for a flat fee? Should I get an advance? What's standard? Because intellectual property is so unique, there is no standard. And in my early days as a lawyer, I would say to clients when they'd ask that question, look, I can prepare a license agreement to effectuate what you want to do. In that license agreement, there's going to be a blank for the royalty amount. You fill in the blank, not me. And that's would have been my answer. but I came to realize that clients didn't like that answer. They wanted me to be more helpful than I was being. So I learned how to help them value the IP. I still don't answer the question, but I help them to think about it in different ways. So if you're trying to value an intellectual property, how would you do it? There are some methods you could use. Yeah.
For the example of the garage, we just think about it. Maybe if it's a big city for the population, how big much bigger space I would need, how it would look like inside, maybe I would give my terms, how it should look. So I will start from there.
If you were the licensor, so you're talking about the way in which the licensee would use the mark, not necessarily how much you'd get paid for it?
No, I would think about if it's a bigger territory, more
Yeah.
population, so the fee should be more bigger, and the value should be bigger. Maybe that's.
Okay, fair enough. How else could you
I
approach
would
it?
count the
First of all-
clients.
Huh?
I would count the clients for the gym.
But you.
Count the clients,
Yeah.
the number of customers.
Yeah, establishing
Okay, or look at the revenue.
other revenue.
Yeah, what else?
Not regarding the gym, but first of all, to see what we are licensing. It's a patent, it's a trademark, it's a copyright.
Sure.
It's even in that,
How much could you earn?
to define an amount.
Okay,
A patent is more expensive than.
well, maybe. I know of a lot of patents that have no value, right? People patent stuff that
Invention.
just to have that piece of paper, it really doesn't have any value. But maybe. What else would you look at? How would you approach it?
Make perspective of how much he can earn.
Ah, how much he could earn. Okay. The income approach.
Income.
All right. So that's definitely one of the approaches that I would suggest a client use.
In this case with the gym, probably I will see how much I did earn by myself.
How much you earn.
Yeah.
How much am I earning? Therefore, how much do I think you're going to earn?
Earn.
Okay. Still the income approach, but good. Okay. So we have some good starting points. Before we talk about, the identified methods, one of which is income, let's shift our brains a little bit because, as we mentioned briefly yesterday, sometimes when talking about intellectual property, it's easier to think about it by way of analogy to real property. Because real property is something it's easier to get your head around, easier for your clients to get your head around. So let's say it's not an intellectual property, but it's real property. If you wanted to figure out how much real property was worth, how would you do it? One way, the income approach, right? How much is this apartment building worth? Well, how much income does it generate? Okay? How else?
How about first we can attack also speaking of the income, but that strategic part. Do we want our product or to be known or to be on some other place? So in that case, we can lower our price for the license if we want our product to be more popular, because that can in future that can affect our income of our main product.
The marketing approach.
Yep.
Yeah. Okay. Fair enough. Okay.
Speaking about the cost, like that should affect the amount of money, because clients would ask how much should I get from the licensee.
Yeah.
And it all depends. What do you want? Like, do you want do you want the money, or you want your product to be popular? Or
Right. Yeah, absolutely.
That all affects.
Okay.
In a real property, it's important even the location.
Yes.
There is not
But
the
go
same
on.
price for every area.
Yes, correct. So,
So to compare
If you
it
want-
with patent.
now let's stay with real property. So if I tell you I want to buy a house right across the street, we know the area.
The price is higher in a good area.
Yeah. So we know the area. How do you figure out how much it's worth?
There's a market value.
Yes, there is.
The market approach. Okay, so we've got the income approach, market approach. What do houses like that sell for? right? This is interesting when I teach this course abroad because in the United States, for real estate, the market approach is pretty much the way it's done because the exact price of every piece of real estate is public knowledge.
Yes,
Is it public knowledge in your territory as well?
yes, there is a decision in our country who defines a minimum price for each area.
A minimum or?
With the point of
A
view of
reference.
taxes, as a reference to pay the taxes in a transaction.
Right, okay.
So there is a
Well, that's good.
value, starting value at least,
Well,
depending
But,
on
well, I'm not talking about the house I want to buy. If where you live, I buy your house, can he find out exactly how much it was without either of us telling him?
No,
Why not?
because then no one discloses, it's not obligatory.
But what about the tax? Is the amount of tax that we
You can
pay?
find out the minimum price at least, yes.
Well, there's no minimum. There's just a price. You sold me a house for X dollars, right? There's no minimum. There's no maximum.
No, the concrete transaction, no.
If
You
you
can't
got,
find out.
if you got connections at the registration,
Yeah,
you
yeah.
sure do, because it should be public information, it's not forbidden. No law says that you cannot look at it
Huh.
and check it out.
But somehow you have to figure out.
And actually, what they do now, before they didn't do it, what they do now in the deed, they put also the value of the contract.
In the deed. So that's a
Yeah.
public record.
So that's the deed, and we have I don't know how to say it in English. Cartel
Cartel promise.
promise.
Property
Uh,
choices.
A chart, let's say,
A
which
chart.
is a description of the property.
Hmm.
And then you have this place, the black space there, where they put also the value
Yeah.
of the transaction.
Okay.
But
It's not,
It's not public.
Not
you
public.
cannot
It's
buy
not
and
public.
find information about the value of my property in the.
no one says it's private, on the other hand. As to the price put it in public, there is, let's say, decision of the government, of the Council of Ministers, which puts reference prices, like minimum
Yeah.
prices.
This is for tax
So
issues.
that's for taxing issue.
Reasons.
If the transaction is above that, of course, you are going to be taxed
Yeah.
over the highest amount.
Yeah.
That's different. So,
So in
That's how it works.
in the United States, the market for this information is a perfect market. There's no minimums or maximums. If I buy your house, the price for it determines a tax. The exact price, there's no minimum, no maximum. The amount of money that changed hands between us determines the tax. And the amount of the tax is public information published. So the day after we conclude our transaction, you can go look at the database and find out what the price was. So for the market approach, you could go down the block, look at that house, that house, that house. The one I want to buy is here. You look at that house, that house, that house, and say, houses on this block sell for. Then there would be a minimum and a maximum because not everyone is going to have to will be sold for the same price. But the information is perfect. And even with the house I want to buy, I can find out if I want to buy it from you. I can find out what you bought it for 10 years ago. Perfect information. So for real estate in the United States, this is the way you determine value.
You start it the opposite, from the tax you pay, you can find out the price.
Yeah, exactly. And it's public and it's fast. And it has been for 30, 40 years in the United States. Okay, so we've got the income approach, we've got the market approach. There's one more common approach to finding valuation. What is it?
Maybe strategic one or
No, it's not strategic, but good guess. Thank you for paying attention yesterday. Market, income, and cost. Again, thinking about it from a real estate perspective, if I want a house if I like your house and I want that house, but I don't want to buy it from you, I can figure out how much it would cost me to build it myself. Right? And again, in real estate, it'd be pretty easy to do that. I could talk to a mason, I could talk to a carpenter, I could talk to a painter, I could talk to a plumber, and I could say, here's what I want, give me the price, and I could put together a spreadsheet that says, okay, if I want that house, this is what it's going to cost.
It depends on
Yeah.
It's the time issue.
All right, so
Depends on-
that's good. Hold on to that thought, because we'll get to, this approach where intellectual property is concerned. But those are three recognized methodologies of valuing something. They work very well in real estate. How much income can I earn from this thing? How much do things like this sell for in the market? And how much would it cost for me to build this thing myself? Those strategies are just as valid with regard to intellectual property as they are for real property. If I want a software program, I can figure out how much it would cost me to create one. I can figure out how much it would cost me to buy it on the open market. If I want Microsoft Word, I could go to Microsoft and say, how much would it cost for me to buy Word from you? I'm not going to get an answer, but at least theoretically I could do that. And I could figure out from Microsoft's publicly available financial statements how much revenue they generate from Microsoft Word. So I could use the income approach. So let's talk about the cost approach to valuation where intellectual properties are concerned. It's easy to envision it for a house, right? Talk to the plumber, the carpenter, the parts and the labor, you come up with a total. What about intellectual property? For this part of the discussion, let's stick with software. I want a software program. How does the cost approach work when figuring out how to value a software program?
How many developers you will need?
How many developers I need? Okay, very good. And how long it will take them? It's probably an hourly rate. Yeah, or salary, whatever. I need 30 people for a year. I'll hire 30 employees at $80,000 a year. This is how much it will cost me. Okay. If you wanted to then assign a value to the IP based on that, so let's say we're considering buying our Microsoft Word, and now we've just figured out how much it would cost us to create Microsoft Word on our own. So in order to use that figure, how much it would cost to create Microsoft Word on our own, in order to give a price to Microsoft, okay, I know how much it would cost me to build it, I'll pay X for yours right now, today. What do we have to do to that figure, that price figure? It would cost me X to build it, so because of that, I'm going to offer you to have your product today. I'm going to modify that number. What would you consider in order to modify that number? Huh?
Not just the cost, but the rating of Microsoft software.
Registration.
How popular is
How popular it is? Well, I would say we're not talking about the brand, we're just talking about the software, right? But your point is valid. I can build one. It might work, it might not. I can buy yours, it works. I know what Microsoft Word is. Even if I'm just buying the technology, not the trademark, I don't get the trademark, I just get the software. But at the very least, I know it works. So it'll cost me $1 million, it'll cost me $100 million to build it, but I know yours works, so I'm gonna offer you 120. Because it's a certainty that it works. Okay? What's another thing to consider? Maybe changes my pricing.
The necessity of that product, maybe.
The necessity of it?
Yeah.
To
For example,
whom? To me?
For Microsoft in this particular case, if you really know that they really need your product, you can extort a little bit more money from them.
Okay, fair enough. Fair enough.
For example, if you're the first one with that product, with that software.
If they're the first one?
No, if you created that software that you want to license to them, so if you're the first one, that can also affect the price.
Okay. Fair enough. What else would I consider? How about the time? The time value of money, right? It's going to cost me $100 million, but I don't pay that money until later, right? I'm going to hire these people over the course of the year. I'm going to pay you right now. So that changes my pricing, the time value of money. Another thing to consider when using the cost approach is, okay, I could build Microsoft Word myself, or I could buy it from you. But I know yours was built 30 years ago. So it's depreciated some. I'm gonna get a brand new one if I build my own. But if I'm buying from you, it's gonna have some wear and tear on it, right? Think again about in the real estate context. If I like your house, but it's 20 years old, I could build my own house just like yours, and it's brand new. Or I could buy yours, and I don't know about all the problems with it. The plumbing leaks a little bit, the floor is squeaky, you know.
When it comes to software, maybe the new one will have more bugs than
Maybe. Okay, so, but it could be the opposite too. Or let's think about, let's shift for a minute into patents, right? Not copyrights. Because patents, we can think more concretely about their lifespan, right?
Yeah.
If I invent this myself, I get a new patent today, it's good for 20 years. I can buy your patent, but there's only 10 years left on it.
Yeah.
It's depreciated. So if it costs me $100 million to build my patented invention, I'm not going to pay $100 million for yours because it's only got half a lifespan left. I'm going to pay you $50 million. So using the cost approach, you have to think about these factors in the same way that you would in the real estate world. What's the time value of money? Am I really going to be successful? Could I really be successful building it myself? Is yours depreciated at all? And it's not a certain way to value an IP, but it's a way to help a client think about it.
And the life circle of the product is also
The life cycle. Yeah, not only of the IP rights, but also the product itself, right? If you've got a 20-year patent on a rotary telephone,
Yeah.
so what? It's not a valuable patent, right? The product itself is obsolete. Yeah. All right, so what about the market approach? So that was the cost approach. As applied to IP, we can at least think about it. It's maybe not a perfect answer. What about the market approach? In the United States, for real estate, market approach is perfect. It's just how you do it, because I can figure out what every house on the block was sold for. In IP, can you use the market approach? Why or why not?
There isn't a place when the licensee or the licensor have the obligation to disclose the license agreement, no, I guess.
Right. The market for information is very imperfect for intellectual property. Typically, there's not a tax paid on the transaction itself, right? There would be an income tax paid or income tax deduction for the buyer, but it's going to be much more mixed up with other financial information, even if their taxes are publicly disclosed, like it's a publicly traded company. There's not going to be a reporting of tax or any other financial information on that transaction. So the market is very imperfect for information. Tough to use the market approach. If I want to find out, let's say, let's say I want to, you have Uber?
Yeah. No.
Here,
Cargo.
here they do.
What is it called? Cargo?
Cargo we have.
Okay,
It's like Uber, but
like Uber,
it's
okay.
the same.
So it's good. But you know what Uber is. So if I want to buy Uber, and I'm looking at the Cargo app, that's not a good analogy. Skip that. So the market approach for intellectual property is imperfect, but if we can find out what other stuff, well, I'm going to go back to this. So not only is the market for information imperfect, but if I'm thinking about buying Uber, the app, and I have the Cargo app, and it just sold, and even if I know how much it sold for, well, these two things kind of do the same thing, but it's very difficult to compare them qualitatively, right? Like houses across the street, one house is kind of like the next, especially if they were built by the same developer at the same time. That house is like that house is like that house. So if I know the pricing information on those houses, I can feel pretty confident that if this one was worth 400,000, that one's worth 400,000. But in intellectual property, they're so unique, it's very difficult, even if you knew how much another one sold for, whether that really is reflective on the one you want to buy or sell. But it's a way to, again, help clients think about a valuation for intellectual property. All right, and then the income approach. So this is sometimes used for real estate if it's like an apartment building or an office building and you're thinking about buying it. Instead of looking at comparable purchases and sales, you might look at how much income it generates. Okay, this building has 10 apartments, each one rents for $1,000 a month, that's $10,000 a month, that's $120,000 a year, and so I think this apartment building is worth 1.2 million, because 10 times a yearly revenue. Okay, we can use the income approach to calculate for real property. What about intellectual property? Is it a valuable approach? What are the pros and cons of using the income approach for intellectual property as opposed to real property?
Maybe the product is not that good, but I would like to try it to see if the value is.
Well, I think you're onto something. So one of the things that the income approach doesn't take into account in intellectual property is, well, especially as compared to real property. If you have an intellectual property that I'm thinking about buying and you're generating $1,000 a month with that intellectual property, I might be better at exploiting it than you, or I may be worse at exploiting it than you. In other words, you might generate 1,000, but maybe I'm not as good at selling as you, so I can only generate 500. Or maybe I'm better at selling than you, so I can generate 2,000. Using the income approach for intellectual property is not perfectly analogous to using the income approach for real property, because real property, again, an apartment costs $1,000. It doesn't matter who's running the place, who's placing the advertisements. The price is pretty much the price. So again, the market for information is pretty perfect. But in intellectual property, the ability to exploit it varies as between you and me. So who knows whether the income, I think, could be generated from it is accurate. That's a problem with using the income approach for intellectual property.
But also, Professor, on the other hand, there are people who know the real estate whole aspect, like they know the market and they know when the bubble is going to come.
Yeah.
Or so they can affect for a huge amount of money on market or real estate.
Sure.
Your house itself.
Absolutely. Even for rentals. Like if you have an
Yeah.
apartment building and you're charging $1,000 a month and you're just not paying attention, you don't know the market, and I know the market, and I think, well, he's only getting $1,000 a month, but I could get $1,500 a month for those apartments. Yes, that could happen in real property too. But I'm still more certain about it than I am in intellectual property. Because if I know the real estate market, it means I know real data. If I think I can get $1,500, I'm probably pretty right. But if I think that I can do a better job marketing Microsoft Word than Microsoft does, well, that's pretty speculative. Maybe I could, maybe I couldn't. Okay. The other thing that the income approach doesn't take into account is the potential for obsolescence or another type of problem. For example, let's now go to the entertainment industry. So let's say it's a song. I want to buy a song from you, and you're Justin Bieber, or George Clooney.
Okay.
I want to buy a song from you, and well, let's say you're Justin Bieber, and because George Clooney doesn't have any songs. Well, let's say it's a movie. Okay, it's a movie, and it's a George Clooney movie, and I want to buy it.
Something more appropriate. Britney Spears.
You're a very successful artist, and I want to buy your whole catalog of publishing rights, right? Which could be very valuable. But I calculate my price based on the income. I know you've been earning $1 million a month on your publishing rights for the last 5 years, And I can feel pretty comfortable that that's going to continue to go on. Maybe it'll, depreciate over time as your music becomes less popular or whatever. But if I use the income approach, and then the day after I buy the publishing rights, you commit a murder, you become very unpopular personally for some reason, the income is going to go down. So in real property, that could happen. Let's say, I don't know, they find toxic waste on the street and all the real property loses value because of it. But it's far more of a risk in intellectual property because I don't know what will happen after I buy
And
the
you cannot
IP.
predict you.
Cannot predict the future. So using the income approach has risk for that reason.
R. Kelly would be a better example.
Yeah. I wasn't sure you guys would know who R. Kelly was because he's such a Chicago story, but yeah, he's a good example.
Yeah.
I thought of him and I was like, oh, So there's the three approaches that we've talked about: the cost approach, the income approach, the market approach, and they're very good in real estate, and for one reason or another, they can kind of work in intellectual property, but at the very least, they give us a framework that we can present to our clients. The only case that I asked you to read for this class in preparation was the Georgia Pacific case, which is a valuation case, right? So for those of you who read it, what did the court do? How did they value the IP? Because that's what a court has to do. In an infringement case, the court or the jury, the trier of fact, has to decide what the damages are. And in order to decide what the damages are, they have to value it. So what did that court consider? Which approach did they use? Cost, market, or income? If you're just refreshing your recollection, that's cool, but don't try and read it now, because you'll never get to it.
Even if you are very frustrated.
Yeah, it'll be a long time.
Don't we have a break now?
No. And it's not worth it to take a break to read this case, because the simple answer from this case is there's no one right answer. What that court did was it looked at the cost, it looked at the income, it looked at the market. How much was I charging for it? How much were you charging for it? They took into account all these factors, and they came to a valuation, which is, our clients, eventually they have to come to sort of yes/no answers, right? Again, going back, in a deal, there's really not like a minimum and a maximum. There's a royalty rate. What is it? Or there's a purchase price. What is it? And at some point, they have to say, all right, it's $1 million, whatever. But you can help them get there by saying, well, consider the cost approach, the market approach, the income approach. And I use this with clients frequently, and I find it's very helpful to make them think about it in terms of real estate first, because everyone can understand that. If you were going to buy an apartment building, how would you value it? And they're like, well, the rent roll. Okay, now let's take that to the IP field. And I think from the perspective of differentiating ourselves as lawyers to our clients and our CEOs, everything we can do to make them think that we think like a business person, not a lawyer, is to our benefit, right? Because they look at us as the cost center, the person who's always saying no, we're too conservative, everything's too long. The more we can look like a business person to our clients and our bosses, the better off we are. Now it's time for a break. 10 minutes.